Good morning, everyone. This hearing of the Senate Judiciary Subcommittee on the Courts will come to order. I'm delighted to be joined by my friend Senator Kennedy as the ranking member of the committee for this hearing. I think that I will take a moment to get some early business out of the way, putting documents into the record. We have a letter from Director Gabe Roth, the Executive Director of Fix the Court, in support of the reforms we're going to discuss today. We have a letter from the Project on Government Oversight. Similarly, we have a letter from the Governance Institute within the Brookings Institution. We have a letter from a considerable number of scholars to Justice Roberts, urging the court to complete and adopt a code of conduct for the Supreme Court of the United States. We have a piece from Nina Totenberg, who is a well-regarded chronicler of Supreme Court activities, regarding the recusal issues arising out of the January 6th related decisions. We have Jane Mayer's terrific piece in the New Yorker on the same issue, which has many statements by legal scholars. We have an article about the Supreme Court battle between Google and Oracle, and the discovery that Oracle and Google were both funding dark money groups to file amicus briefs for them without telling the court. In this case, I think this is mostly about the Oracle effort. And then we have an article from In These Times about the backdrop to the Janus case, which, as many of us know, began with Abood and then had an intermediary decision in which Justice Alito expressed his displeasure with all the related precedent and his desire to overturn it, which then prompted a big rush from dark money groups to get in front of the court to do exactly that in the Friedrichs case, which then failed because Justice Scalia died and they lost the 5-4 Federalist Society majority. But as soon as Justice Gorsuch was appointed, everybody showed up. There was some repositioning with different front groups taking different roles. But then the Janus decision came down and the mission was accomplished. So I add that article to the record. So those are all the public documents that I wanted to put into the record. Then there's some correspondence that comes from, mostly from me, and addresses various different issues. The first letter that I'd like to put into the record comes from me and Hank Johnson, the chairman of the equivalent committee over in the House Judiciary, and it consists of a letter from me and him to Justice Roberts and Clerk of the Court Scott Harris, dated May 13, 2020, to ask them to address the amicus problem. The reply to that came September 18th from the Clerk of Court, and we have that letter. The issue then went to the Judicial Conference, and along with Chairman Johnson, I wrote a lengthy letter to the chair of the Judicial Conference, again regarding the disclosure requirements for amicus briefs. In response to that, the U.S. Chamber of Commerce wrote a letter to the chair of the Advisory Committee on Appellate Rules, and that was on October 6th, and then on November 10th, Chairman Johnson and I replied to that letter. So I would ask that that's all one back and forth exchange of related correspondence. The next topic that we addressed has to do with recusal and conflicts of interest. And we have a letter that a number of senators, including myself, led by Senator Warren, wrote to Chief Justice Roberts and Justice Thomas. We also have a related letter that Chairman Johnson and I wrote to Chief Justice Roberts. We have a letter that I and Senator Blumenthal and Chairman Johnson all wrote to Justice Barrett and Clerk Harris related to recusal, in that case in the Americans for Prosperity Foundation case. So that's another packet of communication back and forth between us and the court related to one of the issues that comes up today. And then finally, on the question of travel and hospitality and what is real personal hospitality and why hospitality from people that justices have never met, provided in commercial settings, appears to qualify in their view as personal hospitality that doesn't need to be declared. This begins with a February 4th letter to Justice Roberts and Clerk Harris from me and Lindsey Graham. And then on July 12th, Lindsey and I, Senator Graham and I, got our reply from Ethan Torrey, the legal counsel to the court, so we have that. In the wake of that, I wrote to all of the circuit courts of appeal, asking them for their view on, in their courts, whether they would accept their judges getting undisclosed free vacations from people they'd never met in commercial resorts and failing to disclose it. That was on August 30th. Got no answer to that. So I renewed the request on April 18th with another letter, this time joined by Chairman Johnson. And then we got this letter April 29th, 2022, just on the eve of this hearing, after months of delay, actually conceding, this is a letter from the Administrative Office of the United States Courts, conceding that these were actually legit questions and that they would look into getting us legit answers, which is rather a different point of view than the original blow-off that we got from the Supreme Court. So this makes twice that persistent questioning from this committee has resulted in work within the judiciary to try to solve these problems. The first was on the amicus issue, which the court initially pretended wasn't real and now is being considered within the Judicial Conference by a special committee. And then now this concern of freebie vacations cranked up with people that the justices don't know at commercial resorts that go unreported. And while the Supreme Court has not expressed much interest in that, the combined pressure of the circuit courts of appeal appears to have started a process. So baby steps, but good steps, and I ask unanimous consent that that whole slew of articles and letters and this series of my correspondence be made a part of the record of this proceeding, and it will be without objection. I see that Chairman Durbin is here, so what I would like to do, because he's the chairman of the full committee, is make a brief opening statement myself, turn to Senator, which way? Kennedy, to do his opening statement, and then turn to Senator Durbin for his opening statement. And I'll first veer from my prepared opening statement to report that today is a hell of a day to be considering ethics questions around the Supreme Court, and particularly the spectacular level of right-wing influence that seems to be the tendency of the Supreme Court since the Federalist Society has taken control of Republican judicial nominations. We do not know yet whether Justice Alito's leaked decision is going to be the decision of the court or not. But as of the moment of this hearing, there has been no disavowal by anyone. So it appears that this precedent is being thrown into the bin, like so many other precedents that displease the right-wing donor base that had such an important role in getting these justices on the court. And of course, the overlay between that problem of right-wing donor influence on the court and the dark money morass that surrounds it has a pretty significant overlay with the ethics questions that we will address here, and which have caused the American public to have a growing and increasingly warranted perception that special interests have taken undue control over our courts. We all know that courts derive their power from public confidence. They don't have armies, they don't have budgets, and we trust judges with the judicial power in the faith that they will not abuse it, that they will treat people fairly and decide matters impartially, not to preconceived ends pressed on them by special interests. Well, it's not going well. In its most recent poll on the subject, Gallup registered the Supreme Court's lowest approval rating ever, a collapse of confidence that coincides with failures of transparency and accountability at the court, conspicuous failures in the areas of gifts and hospitality disclosure, recusal, and identification of amici curiae. The fact that so many justices were selected and their confirmations campaigned for by dark money organizations exacerbates the danger. And the win rate of certain political interests in partisan decisions defies statistical explanation. My counterpart in the House, Representative Hank Johnson, Senator Blumenthal, and I introduced the 21st Century Courts Act last month. It will close loopholes and make sure that the judiciary's ethics rules meet the same standards as Congress and the executive branch. The 21st Century Courts Act is the culmination of work that our offices have done over many years. Our concern takes on new urgency in light of a recent incident that accelerated the public's loss of confidence. Last month, we learned of a Supreme Court justice's failure to recuse himself in a matter where his wife had texted with Donald Trump's chief of staff about strategies to overturn the presidential election. A congressional committee investigating the January 6 attack on our Capitol requested records of communications with the Trump White House. Donald Trump sued to block those records from being turned over, and he asked the Supreme Court to review the challenge. The committee's inquiry could have revealed the justice's wife's texts, yet he failed to recuse himself. This was not an isolated recusal problem. Last April, 3 Supreme Court justices refused to recuse themselves in a case brought by the organizational alter ego of a group that had spent millions of dollars to get the 3 justices confirmed, a group that called one of its efforts a, quote, full-scale campaign to get the justice confirmed. Caperton v. Massey acknowledges that these kinds of campaigns can create at least the appearance of bias, but not only did the justices not recuse, none even deigned to explain. It's not just these recusal examples that are the problem. The court's practice under its personal hospitality rules is peculiar and problematic. Last August, I asked for that explanation from all the circuit courts of their interpretation of the personal hospitality exemption and whether it aligned with what the Supreme Court was telling us. It took the administrative office until last Friday to respond and to admit that no clear guidance exists for the courts on these questions, in contrast to the rules that govern Congress and the executive branch. Amicus groups show up in orchestrated flotillas without disclosing who is behind them, and they enjoy a statistically peculiar rate of success in getting their way at the court. The Judicial Conference is actually at work on Amicus Transparency to, as one judge said, identify the, quote, power behind the throne of these front group amicus filings. An overarching problem is that on these ethics questions, each justice is judge in his or her own cause, without review, transparency, or accountability, and with no place where complaints can go to be addressed. Awkward ethics questions can simply be ignored. One example makes this problem undeniably clear. Actual, ongoing ethics investigations into Judge Kavanaugh were dropped when he became Justice Kavanaugh simply because his ascension to the Supreme Court set him beyond the reach of the ethics rules and procedures applicable to all other federal judges under which he was being investigated. The highest court has the lowest standards, indeed only the standards which each justice, in his or her own unreviewable caprice, chooses to impose on themselves. The biggest thing we could do is likely to pass my Disclose Act, which would make transparent the big money, the big dark money in particular, now being spent anonymously to get justices confirmed. It seems to me essential when someone is spending millions of dollars on judicial confirmations to influence the makeup of the court to understand what business they may have before the court. The court's reluctance to treat any of these issues seriously puts us in the position of having to act legislatively. To be clear, we need to root out problems with our judiciary's ethics practices so that we can protect the public's trust in our federal courts. We need to update the laws and practices regarding recusal. We need safeguards to protect against the dark money influence that now enmires the federal judiciary. We need rules for disclosure of who is behind front group amici. And we need a binding code of conduct for the Supreme Court, the only court in the country that doesn't have one. Justices say they can handle these problems themselves. We may hear more of that today. But they've had plenty of time and plenty of cause, and they simply have not. So today we consider what Congress can do to address those ethics issues and to assure that the court's rules and practices merit the confidence and trust of the American people. And with that, let me turn to my distinguished ranking member, Senator Kennedy.
Thank you, Mr. Chairman. Thank you to all our witnesses. I will not be a part of any effort that is intended to or has the consequence of destabilizing the institution of the United States Supreme Court or our federal judiciary. I won't do it. I will not be a part of any effort to change the United States Supreme Court because I do not like the way that it is voting. The integrity of the court is as important as the integrity of this body. It is as important as the integrity of the executive branch. It is as important as the integrity of the United States Constitution. Judges are not supposed to be politicians with robes. Judges are not supposed to tell us what the law ought to be. They are supposed to tell us what the law is. That doesn't mean that sometimes judges don't make law. What's reasonable or unreasonable under the Fourth Amendment is a topic that our judges have to assess every day. But they have to, or at least they should, assess it with an open mind and with an understanding of the purpose of that constitutional amendment. Now, this is America. You're entitled to believe what you want, and you're entitled to say it. I don't much agree with my woker fellow Americans who think they're smarter and more virtuous than the American people, who think they have a monopoly on the truth. I believe they have the right to say what they want to, but I also believe you don't have the right. You're not really free if you can't express yourself, if you can't say what you think. So I'm not suggesting that this is not a topic that we shouldn't talk about. In fact, I'm interested in hearing what all of you have to say, particularly about the consequences, if any, of this legislation on the separation of powers. I think I'm rather fond of the Constitution. I'm rather fond of the part about the three branches of government. I'd like to maintain them. I'd like to lift up the institutions of the Constitution, including the United States Supreme Court. I'm not interested in tearing them down because I don't happen to like the way they vote. Dark money has been mentioned repeatedly. A great deal of money is being spent by conservatives, moderates, liberals in America. They have the right to spend that money to petition their government. I don't think it's fair just to blame one particular side. You know, the American people aren't stupid. They're not morons. They may not read Aristotle every day because they're too busy earning a living. But the American people can see that all sides are represented in this so-called dark money. I've been disappointed in the way the Supreme Court has voted before. I've been reading Supreme Court opinions since I was in law school. And I realize what you're thinking. You know, life is short. Kennedy should get one. But I enjoy reading Supreme Court opinions. For the longest time, it was part of my job when I taught in law school. Some of them I agree with. Some of them I don't. But I have never, and never will, attack the institution of the United States Supreme Court. Now, we're about to find out what our Department of Justice is made of. We have had an unprecedented leak. Unprecedented. As despicable as it is dangerous at the United States Supreme Court. And for those who don't understand how the United States Supreme Court works internally, it's not like the United States Congress, where thousands of people could have access to a document. This is a very finite group of folks who could have had access to that document. And this leak, regardless of whether you agree with the draft opinion or disagree, has seriously undermined the confidence that we all have in the United States Supreme Court. We're about to find out what the United States Department of Justice is made of, because it can find this leaker if it wants to. And once that leaker is found, that person should be fired. That person should be disbarred. That person should be the defendant and whomever cares to bring a civil lawsuit. And that person should be prosecuted. That person also has a pretty difficult decision to make here in the next few days. I hope that I'm accurate, believe I'm accurate, in suggesting that every person who had access to this document that was leaked, is going to get a visit by the FBI. And the person who leaked this document is going to have to either tell the truth or lie to an FBI agent, which subjects them to criminal prosecution. So let's hope that our Department of Justice does its job. And in at least a small way, tries to restore a little bit of the integrity that this misguided zealot who leaked this document took away from the American people. I look forward to your testimony.
Thank you, Senator Kennedy. It's an interesting separation of powers question. Why FBI agents from the executive branch should be running around within the Supreme Court interviewing clerks and staff and justices themselves, if it's not appropriate for Congress to exercise its legislative powers with regard to those standards. So it will be interesting to see that.
Well, let me respond to that, Mr. Chairman. As you know, the United States Supreme Court has its own police force. And I don't think it's at all uncommon to have police forces cooperate. And what I hope happens, everybody's entitled to his opinion, but what I hope happens is that the authorities at the Department of Justice, who I believe will be called in, should be called in, put the full force and power of their agency to find out who leaked this document and to prosecute that person civilly and criminally to the full extent of the law. I don't care who it is. I don't care what their politics is. This isn't right.
And I guess we'll begin by trying to identify what law that person might have violated. Let me turn to Chairman Durbin to make his opening statement.
Thank you, Mr. Chairman. Yesterday, I attended a memorial ceremony at the Supreme Court for former Justice John Paul Stevens. It was a moving ceremony in honor of a man I respected very much and a great justice. And it brought to mind a line that Justice Stevens wrote in his famous dissent in the Bush versus Gore case. Let me read it. It is confidence in the men and women who administer the judicial system that is the true backbone of the rule of law. Time will one day heal the wound to that confidence that will be inflicted by today's decision. One thing, however, is certain. Although we may never know with complete certainty the identity of the winner of this year's presidential election, the identity of the loser is perfectly clear. It's the nation's confidence in the judge as an impartial guardian of the rule of law. I think of this quote again today as millions of Americans wake up to the realization that a constitutional right that has been guaranteed for half a century, that they may have known their whole lives and assumed was, quote, settled law, is suddenly on the verge of being extinguished. I don't condone the leaking of internal Supreme Court documents. Senator Kennedy's correct. It is unprecedented. I don't know who leaked the opinion or why. But I know that today, women and men across this country are grappling with the very real concern and, yes, the fear that they may lose a critical constitutional right in just a matter of weeks. If true, this draft opinion that circulated last night would end a half-century guarantee that reproductive rights are protected by our Constitution. Everyone, no matter where you live or how much money you make, deserves access to health care without barriers or political roadblocks. Regardless of the Supreme Court's final decision this summer, Congress cannot sit idly by, nor can this committee. We must enshrine into law a woman's right to make her own health care choices. Long before last night's news, this hearing had already been scheduled to discuss the issues of judicial ethics and transparency. They are important topics, and I welcome the distinguished panel of witnesses here today. I do not take anything near a hands-off attitude toward that branch of government known as the judiciary. As a matter of fact, we just completed an advise and consent procedure for a nominee to the highest court of the land. We do that for judicial nominees at the federal level. We actually determine how many of those judges will be sitting on circuit benches and district court benches. We have the power, though it's been a long time since it's been actively debated or discussed, to even change the composition of the courts. We have many authorities, including the power of the purse when it comes to dealing with the judiciary. So I don't take a hands-off attitude. While we're on the subject, I think we should consider the ethical implications of Supreme Court nominees repeatedly coming before this committee and testifying under oath that they will respect precedent and then doing exactly the opposite when they're confirmed. We must work to ensure, as Justice Stevens said, the true backbone of the rule of law, the confidence in the men and women who administer it. I believe that confidence has been shaken, and we must face that alarming reality. Stronger ethics rules will increase public confidence in the courts and will add legitimacy to their rulings. This will in turn increase public confidence in our democracy. This is not about any particular judge or justice. It's about our federal judicial branch. When we argue the judiciary needs stronger ethics rules, that doesn't mean that federal judges are behaving unethically on any widespread basis. But the Supreme Court itself has recognized that laws governing judicial ethics are not just about regulating actual ethical lapses. They are about avoiding the appearance of impartiality. In recent years, there have been numerous bills in Congress taking a variety of approaches to strengthen judiciary ethics. Just last week, the House passed the Courthouse Ethics and Transparency Bill, which had passed the Senate in February. This bill, led by Senators Cornyn and Coons, increases the reporting requirements in judges' financial disclosure forms and makes those forms more accessible to the public. Hope we can find a path forward for more bipartisan action. I want to thank this panel of witnesses again. I look forward to hearing from you. Thank you, Mr. Chairman.
Thank you very much, Chairman Durbin, and thank you very much for attending our hearing. I'm grateful to you. The witnesses I will now introduce, and I'll just go right across the table here. First is Kedrick Payne, who is the Vice President, General Counsel, and Senior Director of Ethics at the Campaign Legal Center. Prior to joining the Campaign Legal Center, Mr. Payne advised the executive branch on ethics laws as a Deputy General Counsel at the U.S. Department of Energy, and he's also enforced legislative branch ethics laws as Deputy Chief Counsel of the Office of Congressional Ethics. Before that, he was in private practice at Skadden Arps, Slate, Meagher, and Flom, where he advised lobbyists and government contractors on compliance with government campaign finance and ethics laws. Mr. Thomas Dupre, you mind if I introduce your witnesses? Are we good to do that? Is partner and co-chair of the Appellate and Constitutional Law Practice Group at Gibson, Dunn & Crutcher here in Washington, D.C. He previously served as Deputy Assistant Attorney General and Principal Deputy Assistant Attorney General for the Civil Division at the U.S. Department of Justice during the George W. Bush administration. He's argued more than 90 appeals in federal courts in all 13 circuits and the United States Supreme Court. Professor Amanda Frost is the Ann Loeb Bronfman Distinguished Professor of Law and Government at American University Washington College of Law. Professor Frost writes and teaches in the fields of constitutional law, immigration and citizenship law, federal courts and jurisdiction, and judicial ethics. Professor Frost's scholarship has been cited by over a dozen federal and state courts, and she is the author of two especially relevant law review articles on judicial recusal and judicial ethics laws. Before Professor Frost entered academia, she clerked on the U.S. Court of Appeals for the D.C. Circuit and spent 5 years as a staff attorney at Public Citizen. Professor Jennifer Mascott is an assistant professor of law at the Antonin Scalia Law School of George Mason University and the co-director of the C. Boyden Gray Center for the Study of the Administrative State. Professor Mascott writes and teaches in the areas of constitutional law, administrative law, separation of powers, and federal courts. She previously served as an Associate Deputy Attorney General in the U.S. Justice Department and as Deputy Assistant Attorney General within the department's Office of Legal Counsel during the Trump administration. She has clerked for Justice Clarence Thomas and then Judge Brett Kavanaugh. And finally, Professor Abby Wood is a professor of law, political science, and public policy at the University of Southern California, where she teaches classes on administrative law, money in politics, and research methods. Professor Wood holds a JD from Harvard Law School, an MALD from the Fletcher School of Law and Diplomacy at Tufts University, and a PhD in political science from UC Berkeley. Her research uses quantitative and experimental methods to evaluate the effects of transparency laws and courts' decisions, and she's published several articles on dark money and disclosure. In addition to her work as a professor, Professor Wood also serves as a commissioner for California's Fair Political Practices Commission. This is a distinguished panel. I welcome you all, and if we can begin with the summary of your testimony from Mr. Payne. Please proceed, sir.
Thank you for the opportunity to appear before you today at this important hearing. The purpose of my testimony is to compare the ethical standards in the judicial branch with the ethical standards of the executive branch and the legislative branch. In particular, ethics laws and rules governing the Supreme Court do not have basic provisions that exist in the other two branches. As a result, the court has faced many years of allegations of actual and perceived conflicts of interest. Also, public polling shows decreasing approval ratings of the Supreme Court. When other branches of government have faced similar public concern with conflicts of interest, stronger ethics laws have been adopted. The reason for such reform is that strong ethics laws are needed to decrease conflicts of interest and thereby increase public confidence in government. Public confidence in the impartiality of those who serve on the highest court is of the highest importance. And one way to improve the lower ethical standards of the Supreme Court is to adopt stronger ethics laws that have been effective in the other two branches. To this end, there are 3 areas of reform that should be considered to enhance ethics in the Supreme Court. First, the Supreme Court does not have a compliance mechanism for its recusal requirement. The justices are subject to a recusal requirement that disqualifies them from participating in decisions where their impartiality may be questioned or where they may have other conflicts of interest. Despite this requirement, there have been many allegations of justices failing to recuse themselves from matters where there is an apparent conflict of interest. One reason these recurrent allegations occur is that there is no method to facilitate compliance with the recusal rule. The court can learn from the compliance mechanism of the executive branch recusal rule. In the executive branch, compliance with the recusal rule relies in part on public disclosure of ethics agreements that senior officials create with ethics counsel. These public documents clarify potential conflicts and matters on which the officials must recuse. A similar disclosure requirement will support compliance of the court's recusal rule. Specifically, each justice should disclose the rationale of their decision on whether to recuse from a particular matter. This disclosure will decrease uncertainty and speculation about the reason for a justice's non-recusal. The disclosure will also help to establish precedent on how the recusal rule is interpreted. Second, the Supreme Court does not have a code of conduct. The executive and legislative branches have adopted codes of conduct to prohibit common conflicts of interest and support public trust in government. The Supreme Court has not. Unless the Supreme Court establishes a code of conduct to formally define and prohibit ethical misconduct, the judicial branch will remain the branch with the least developed ethical standards. A Supreme Court code of conduct should provide concrete standards for the appropriate conduct of justices. A code of conduct can demonstrate to the public that the court is willing to hold itself accountable for conflicts of interest and other issues that are not currently codified in law. Finally, the Supreme Court does not have meaningful disclosure of privately sponsored travel. Supreme Court justices frequently attend trips paid for by private entities, which is permitted for certain educational purposes. However, the number of trips, recreational nature of the trips, and limited disclosure of the trips results in public criticism of potential conflicts of interest. In contrast, the legislative branch established extensive disclosure requirements for its members after facing ethics scandals involving privately sponsored travel. Members of Congress now publicly disclose details regarding the cost of trips, sponsors, attendees, and event schedules. More extensive disclosure requirements for privately sponsored travel could increase confidence in the integrity of the court. In conclusion, ethics rules in the executive and legislative branches can serve as models to improve Supreme Court ethical standards and increase public trust in the judiciary. Thank you again for the opportunity to appear before you today, and I welcome any questions you may have.
Thank you, Mr. Payne. I appreciate your testimony very much. Mr. Dupre, please proceed.
Thank you, Senator, for inviting me to testify today and to share my thoughts on the 21st Century Courts Act of 2022. Today, I would like to focus on two sections of the bill before the committee. Section 2, which is the provision ordering the Supreme Court to issue a code of conduct governing the justices themselves, and Section 5, the provision that would impose new disclosure requirements on amicus briefs filed in the Supreme Court and the Courts of Appeals. Let me start with Section 2. This is an extraordinary mandate that infringes on the separation of powers, a bedrock and inviolable principle that underpins our constitutional democracy. Our founders well understood the importance of separating the legislative branch from the judicial branch. As the Supreme Court has explained, the framers of our Constitution lived among the ruins of a system of intermingled legislative and judicial powers, which had been prevalent in the colonies long before the Revolution, and which after the Revolution had produced factional strife and partisan oppression. The lesson of this shared experience is reflected in the words of James Madison, who wrote in Federalist 47 that the preservation of liberty requires that the three great departments of power should be separate and distinct. Ordering the justices to adopt the code of conduct within 180 days offends the separation of powers. So does threatening the justices by providing that a code of conduct will be forced upon them if, in the bill's ominous words, the Supreme Court of the United States fails to comply with the congressional mandate. The bill intrudes upon the core functions of a coordinate and co-equal branch of government. It is the Supreme Court, not the Congress, that has the prerogative under our constitutional structure to decide whether to adopt a code of conduct governing the justices themselves. As Chief Justice Roberts has written, courts require ample institutional independence, and the judiciary's power to manage its internal affairs insulates courts from inappropriate political influence and is crucial to preserving public trust in its work as a separate and co-equal branch of government. Adopting some of the recusal provisions, including in this bill, would open the door to a tidal wave of disqualification motions in virtually every important case. Round one and all the big-ticket constitutional cases would be litigation over which justices are eligible to decide the case and which justices must be disqualified. It is hard to imagine anything more corrosive to public faith in the Supreme Court than what would become routine volleys of motions alleging that various justices are ethically compromised and must recuse because they accepted a meal from someone distantly connected to a case. As Justice Scalia once wrote in denying a request that he recuse, while the political branches can perhaps survive the constant baseless allegations of impropriety that have become the staple of Washington reportage, this court cannot. The people must have confidence in the integrity of the justices, and that cannot exist in a system that assumes them to be corruptible by the slightest friendship or favor. Let me turn to Section 5. the bill would impose a host of disclosure requirements on those who file amicus briefs in the Supreme Court or a court of appeals. The purpose of an amicus brief, literally a friend of the court brief, is to assist the judges. A good amicus brief does not simply echo the parties' briefs, but provides a different perspective, often one derived from the amicus's own experience. The disclosure requirements set forth in Section 5 are unnecessary. The Supreme Court and the federal courts of appeals already have disclosure requirements that govern amicus briefs. If the justices and judges on the Supreme Court and the federal courts of appeals believe that additional information would help them evaluate the arguments presented in an amicus brief, it is their prerogative to require that information. These disclosure requirements would result in far fewer amicus briefs being filed. That, in turn, would result in the courts receiving far less information and hearing from far fewer voices when they decide cases. The disclosure requirements would also chill and penalize constitutionally protected conduct by requiring amici to disclose people who contribute to their organization. The bill would put a steep price on the exercise of First Amendment rights, including the right to free speech, the right to assemble, and the right to petition the government. The bill tells those who want their voices to be heard in our federal courts, you may speak, but only if you turn over your contributor list. Allow me to close by saying that the two provisions of the bill I have discussed today seem to be animated by a dark and distorted perception of our judicial branch, a perception that is fundamentally at odds with what I have seen in more than 20 years of practice in the Supreme Court and the courts of appeals. In my experience, speaking as someone who's argued in front of hundreds of federal judges throughout the country, our federal bench is populated by men and women of the highest integrity. And even when I disagree with the outcome in a particular case, I have never doubted for a moment that these are judges who are striving to do their absolute God-given best to faithfully interpret the laws and the Constitution of our great nation. Thank you.
Thank you, Mr. Dupree. Professor Frost.
Chairman Whitehouse, Ranking Member Kennedy, and distinguished members of the committee. My testimony today will focus on two areas. First, I will discuss the need for reforms in the process by which judges and justices recuse themselves. And second, I will discuss Congress's constitutional authority to legislate in the area of judicial ethics. So I will begin with the recusal issue, and I will begin with a hypothetical. Imagine that sitting on the Supreme Court is a justice who in the past had been on the board of overseers for a prominent university. Imagine that that university then has a case before the court as a party to a case in which that university's admissions policies are being challenged. Under the current recusal statute, 28 U.S.C. section 455, and the court's longstanding practice, here is what would happen next. First and most important, the only person who would decide whether that justice should recuse or would recuse is that justice herself. No one else would review the decision or play any role. Second, that justice does not need to tell anyone, including the parties, what role she may have played in setting the admission policy or overseeing that policy, even though it's the subject of the case before her on the court. And third, whether or not she recuses herself, that justice does not need to explain, and typically would not explain, the basis for her decision. I would like to think that all of us in this room could agree that that process is deeply flawed and undermines the purpose of the recusal statute, which is to protect the litigants from biased justices and judges, and even more important, to protect the integrity and the reputation of the court. And that process should be reformed. Now, as an aside here, I will say what we all know, which is that my hypothetical is very loosely based on the situation of recently confirmed nominee to the Supreme Court, Ketanji Brown Jackson, but with an important exception. In her case, she was asked at her confirmation hearings if she would recuse in a case involving Harvard University because she'd served on the Board of Overseers. She forthrightly and candidly said yes. But when other justices have been asked at their confirmation hearings about recusal, they often do not respond, and nothing in current law would require them to do so. I'm going to turn now to the question of Congress's constitutional authority to regulate judicial ethics. And I'll start off by saying that the decisional independence of the Supreme Court is essential. I would be the first person to speak against any law that undermined that decisional independence, which is clearly so vital to the framers and to our system. But that's a very separate question from whether Congress can regulate the administration of the court, including its ethics. And when we look to a question like that, a separation of powers question, We look to two sources to guide us. One is the Constitution's text, and the other is long-standing historical practice. And in this case, both strongly support Congress's power to legislate ethical rules and guidelines for the judges and justices. The Constitution establishes the U.S. Supreme Court as one must exist, but it contains no details about what that court should look like, where it should meet, how many members it should have. All of the details of that institution have been left to Congress, and Congress immediately took up that authority under the necessary and proper clause under Article 1 to do so. The first Judiciary Act of 1789 established all the requirements for the court to meet, when it should meet, where it should meet, its membership, its budget, its personnel, etc. So Congress not only can, but must legislate to bring the Supreme Court into existence, and it has chosen to do so for the lower courts as well, as is its authority under the Constitution. Judicial ethics has also been a topic which Congress has legislated on from the very beginning. In 1792, it enacted the first recusal statute. For the past 75 years, that statute has also applied to the Supreme Court justices. Major pieces of ethical legislation apply to the courts as they do to the executive branch, such as the Ethics Reform Act of 1989 and the Ethics in Government Act of 1978, which all members of the courts, all Article 3 judges, comply with. Finally, Congress requires every judge and justice sitting today to take an oath, and that oath includes the requirement that they swear to do equal right to the poor and to the rich, and, quote, to faithfully and impartially discharge and perform their duties. If Congress has the constitutional authority to require judge and justices to swear to be impartial, it certainly has the authority to require and pass laws to ensure that they fulfill that obligation. Thank you for the opportunity to testify, and I look forward to your questions.
Thank you, Professor Frost. Professor Mascott.
Chairman Whitehouse, Ranking Member Kennedy, and members of the subcommittee, thank you for the opportunity to testify today. I'm Jennifer Mascott, a professor at the Scalia Law School, where I teach and write in the areas of constitutional interpretation, federal courts, and civil procedure. And as the theme of my written prepared testimony reflects, the best way to preserve and sustain the legitimacy that the Supreme Court has enjoyed for decades is for the court to maintain consistency with its proper constitutionally constrained role. Article 3 of the Constitution authorizes federal courts to resolve discrete cases and controversies. Courts are not political institutions, and when society treats the court as a political entity and improperly turns to the court to solve society's problems, the court is undermined, and we will see outrages like the unprecedented breach of integrity and attack on the court that we saw last night. It's impossible today not to begin the summary of my written testimony by addressing what appeared to be a leak last night of an original draft opinion in the court's upcoming decision in the Dobbs case. As a former law clerk for the Supreme Court, I'm shocked by the leak. This leak is unprecedented in its breadth in the history of the Supreme Court, and I fear what it will do to undermine the trust, confidence, and collegiality that the justices have enjoyed to this point in spite of the broader divisiveness of the culture. But in a society that bullies and intimidates the justices, we get attacks like we saw last night in individuals who feel that when they don't like the outcome in a particular decision, they need to attack and undermine the legitimacy of the court that's reaching the outcome and trying to apply the rule of law. That said, despite the individual aberration of last night trying to undermine the legitimacy of the court, the Article 3 judiciary arguably has been the most stable, best functioning branch within the federal government. The number of seats on the Supreme Court's been steady for more than 150 years. Over the past 10 terms, at least 35% of the court's judgments in merits cases have been unanimous, and the court's decisions are breathtakingly transparent in the level of detailed explanation that the court provides in written opinions when it resolves orally argued cases. President Biden began his administration with an effort to probe whether the Supreme Court needs significant reform, and the President's Reform Commission saw no unified mandate to urge far-reaching reform, advising instead that many of the suggested structural changes to the court that the Commission evaluated would offer uncertain practical benefits. The Constitution authorizes Congress to establish federal courts and assign their scope of jurisdiction over cases and controversies, so Congress has the power to prescribe certain rules impacting the operation of federal courts. Dating back to the first federal Congress, however, the House and Senate authorized federal courts to devise their own procedural rules subject to significant discretion. There may even be a certain core constitutional minimum of supervisory authority that the Supreme Court must maintain over its own operations that Congress would lack the authority to regulate, even if it had the political will to do so. Regardless of the statutory or constitutional character of judicial supervisory authority, however, the practice of Congress has been to authorize and affirm the ability of the courts to exercise significant internal supervisory power over their own operations. Contemporary political considerations are not a solid ground on which to change this centuries-old general practice and approach. If there's any factor causing the courts to appear to lack sufficient accountability and transparency, it would be the trend over the past century for the American public and its institutions to turn to the court to sit as the final arbiter of significant social and political questions. The expectation that the court will resolve some of the most contentious issues of our time on a broad scale, such as privacy issues, family and education policy, and the proper demographic makeup of societal institutions, misconceives of the court's proper constitutionally constrained role to resolve concrete cases and controversies. The Constitution established Congress and the executive branch to serve as the federal lawmaking and law executing departments. Through regular elections, Congress and the President are accountable to the representative will of the public and therefore are appropriately charged with making and executing policy. And Congress is the singular federal branch on which the Constitution expressly imposes disclosure requirements for that very reason. Congress should not apply mandates and restrictions to the courts that would make courts resemble the political institutions. Rather, the federal government should reduce its sphere of governance across the board, permitting more space for individual states, families, and religious and educational institutions to provide tailored and localized policy solutions and self-governance. Thank you. I look forward to answering your questions.
Thank you, Professor Mascott. Professor Wood.
Chairman Whitehouse, Ranking Member Kennedy, and distinguished members of the subcommittee, thank you so much for inviting me to come today to talk about dark money and the judiciary. When I searched flights for my travel here, my results included greenhouse gas emissions data for each flight. That information, which was made available at the time that I made my decision, affected my decision. I chose a flight that had a slightly lower impact on the environment because I had the information. I know from years of researching disclosure that this simple and kind of toyish but true commercial example demonstrates the power of disclosure to aid our decision-making. Well-designed disclosures can help us decide how to vote, what to buy, where to eat, which doctors and financial advisors to trust, and yes, which judges and justices and amici to trust as well. There are three things I want you to know about disclosure of political spending generally. First, disclosure informs decision makers, as does disclosure about disclosure, which I'll explain. Second, concerns about disclosure chilling speech and association seem overblown. Third, because dark money damages political trust, more disclosure is needed around both judicial confirmation and amicus briefs to shore up the public's declining view of the court's democratic legitimacy. On the first point, disclosure informs decision makers. As I detail in my written testimony, we have decades of research into the informational benefits of campaign finance, consumer, and conflict of interest disclosures. And in this age of dark money, scholars are also learning that disclosure about disclosure is powerful. By disclosure about disclosure, I'm going to say disclosure a lot, sorry. I mean a disclosure that informs a decision maker that the speaker does not disclose its donors. Some of our studies inform survey respondents that an advertisement they saw was funded by anonymous sources or that a candidate has support from so-called dark money groups. Respondents react negatively to that information. This matters for a potential second best or negotiated option for amicus and confirmation financing disclosure, which would be to disclose the fact of the dark money support, if not the donors themselves. Disclosing the donors themselves is better for everyone involved, but disclosure about disclosure would be better than the current policy, which keeps too much hidden. Second, claims that disclosure chills speech are overblown. We have over 500,000 elected positions in this country. Suppose that each seat has 2 candidates and each of them has 20 donors. Of course, Some candidates run unopposed. Some candidates have thousands of donors, but we're going to keep the math simple. On my example, that's 20 million people donating money every cycle. When you add the people who don't donate but allow yard signs, volunteer publicly, and otherwise publicly participate, we quickly get to a very large number of people speaking and associating themselves with political candidates and stances. Yet the number of serious threats based on political activity that any of us hear about in any given decade is vanishingly small. The advocates for political anonymity who use the risk of harassment as a rationale for their chilling are not being realistic. What's more, in 2 studies, my co-authors and I have shown that there's no actual chilling effect from the disclosure laws we've studied in the context that we've studied them. Depending on measurement, disclosure may actually thaw speech. Therefore, exemptions from mandatory disclosure should be allowed only rarely and only when there's a likelihood of serious harm, especially when that harm would emanate from the government, as was the case in NAACP v. Alabama. Most parties who oppose disclosure these days are among the most privileged members of our society, and they avail themselves of the shield created by NAACP v. Alabama, fashioning it into a sword to attack our democracy. The solution is a mandatory disclosure regime with very high standards for exemptions from disclosure. Finally, dark money damages political trust. In our research, we know that when respondents learn about dark money, their trust and credibility evaluations decrease. They rate the candidate or advertisement they see as less trustworthy or less credible. Our courts, lacking both the sword and the purse, must protect their democratic legitimacy to continue to receive the public's compliance. Improve transparency around the money spent in judicial confirmation battles and in amicus briefs is one step towards shoring up our judiciary's democratic legitimacy. Thank you for your time. I look forward to your questions.
Thank you very much. This has been a very good panel. I appreciate everybody's testimony. Let me begin with my own questioning, and then the order as we have it is Senator Kennedy, Senator Durbin, Senator Graham if he returns, and Senator Blumenthal. Mr. Payne, you have studied ethics reporting and disclosure in the executive, legislative, and judicial branches. What would you identify for this committee as the worst discrepancies where the judicial branch does not meet the standards that are currently imposed for legislative and executive branches?
The Supreme Court lacks disclosure with travel that's privately sponsored when you compare that with the legislative branch. The Supreme Court lacks disclosure with recusal requirements and compliance with the recusal rule, which you have in the executive branch. And the Supreme Court lacks disclosure with the code of conduct or the ethical standards that are applied to the justices and their staff, which is in contrast with what is available in the executive and legislative branches.
Just to put a practical example on this, if a big donor or a big political interests representative wished to entertain a Supreme Court justice, and if they went to the owner of a yacht cruising in the Mediterranean or a ski chalet in Aspen or a beach resort in the Caribbean, and they asked the owner of that resort to invite a justice of the Supreme Court for a free vacation, and perhaps even invited some of their friends to enjoy the companionship of that judge during that free vacation. Under the current reading of the disclosure requirements by the Supreme Court, because the invitation came from the owner of the property, that would be viewed as personal hospitality, notwithstanding there being no personal relationship whatsoever between the owner and the justice. And therefore, the justice could follow that rule to fail to report the free vacation. Is that correct?
It is definitely possible that a justice in that situation could try to rely on the personal hospitality exemption to disclosure because the way that rule is interpreted is not clear by the courts, and it could be used in that way.
And because they each get to make their own unreviewable decisions, there's nobody else to say, wait a minute, that's not legit, which brings us to Professor Frost. It is a principle of justice that is so old that it was originally framed in Latin, that no person shall be judge in his or her own cause. And furthermore, the record of judicial proceedings shows beyond doubt that federal judges get recusal wrong. They get recusal wrong all the time, and there's a record of appeals of judges getting recusal wrong that proves that fact. So we know that judges can get recusal wrong because they do all the time. Why does it make any sense then to have Supreme Court justices have the privileged and improper position of being judge in his or her own cause as to recusal?
I entirely agree with you. The Supreme Court is, at this point, the only members of the federal judiciary who have no outside check on their decision to recuse. And as I said in my testimony, that undermines the purpose of the recusal statute, which is twofold: to protect the litigants from a biased decision maker, but I think even more important, to protect the reputation of the court itself. And there's an easy fix, which is to have all 9 members of the court. We could debate whether it could be 8 and the justice who's potentially needing to recuse could step out, or whether all 9 could do it. Either way, it would be an improvement. And review the recusal question and make a decision. And that would both ensure the litigants that they were receiving impartial justice, but even more important, it would reassure the American people that the potentially biased decision maker is deciding for him or herself whether or not they should step aside.
And Ms. Wood, a question to you about the anonymously funded amici. Judge Millett has said that it's important for courts to understand who the, quote, power behind the throne is when a amicus shows up in court. The procedures for anonymous appearances in court are generally very rare and very carefully and scrupulously maintained. And there's the danger of orchestration. Indeed, we've seen right-wing funders memos describing their efforts to orchestrate multiple amicus briefs in a particular case. Could you comment on those reasons for why there should be amicus disclosure?
Absolutely. So regardless of whether it's right-wing or left-wing, when we have coordination behind amicus briefs, it does a couple of things. So one, it helps the parties circumvent the page limits in their briefs because they're able to not only have the one bite at the apple that they're allowed before the court, but then they're allowed to bring kind of supplementary arguments through amici, which is just, it kind of undermines our adversarial system. Secondarily, as I was saying before, the justices need to know where the actual source of the argument is. They need to know that because, as we've shown in so many other contexts, that kind of disclosure affects our decision making. It will let them know how much to weight the decision, right? We already know from something that Justice Ginsburg said a while back that they put them in 3 piles, okay? Don't read, maybe read, definitely read. Where we get the source of the actual argument that comes before the court via an amicus, that might affect which pile it goes in. So I think it's really crucial.
Thank you. My time is up. In fact, that answer took me a little bit over it, so I apologize
Sorry.
to my colleagues. Senator Kennedy.
That's okay, Mr. Chairman, thank you. I've enjoyed your testimony. Professor Frost, I take it that you think the recusal provisions that the United States Supreme Court uses are inadequate. Yeah, I'm interested in learning more about that. Do you think they undermine, they meaning the recusal provisions at the United States Supreme Court, undermine the integrity of the court?
I do, and I think that what is unfortunate is there's some easy ways to fix and change this, which of course is in Congress's hands by adding procedures to the recusal statute.
Let me ask you, what do you think undermines the integrity of the United States Supreme Court more, in your judgment? Its recusal provisions, or a member of the United States Senate going to the steps of the Supreme Court and threatening justices by name if they don't rule the way he wants on Roe v. Wade?
So I take it that this hearing is to consider a bill and to consider possible legislative reform to improving the way the court operates and protecting actually all the Article III courts. So that's going to be the focus of my testimony. And here's what this institution could
Yes,
do.
ma'am, but first, could you answer my question?
So your question is whether people speaking out against the court is more damaging to the court
Wasn't my
than...
question. My question is, what do you think undermines the integrity of the United States Supreme Court? The inadequacy, in your opinion, of its recusal provisions, or having a member of the United States Senate go on the steps of the United States Supreme Court in front of God and country and threaten justices by name if they do not vote the way he wants them to vote on Roe v. Wade?
So, Senator, unfortunately, over the last decade, particularly the last 5 years or so, I have seen the court come under attack from so many different sources.
Yes, ma'am, but what about that particular?
That I think that's a problem. I would certainly not support a senator criticizing the court. It's also a problem when the Senate of the United States will not confirm a nominee for over a year, leaving the court at 8 justices. And it's also a problem when Congress will not amend existing legislation to improve the process of recusal so that all of the justices can weigh in on a recusal decision and protect the integrity of that court. All of those are a problem.
Let me ask each of you this. You're all students. Well, first, I'm going to call you professor anyway. I think you're qualified to be a professor, Professor Payne. You mentioned ethical misconduct by the United States Supreme Court justices. Can you give me examples in the last 20 years of specific acts of ethical misconduct by the United States Supreme Court justices?
I can definitely send you the allegations of misconduct. In the Supreme Court, the perception of misconduct has the same impact as actual misconduct.
But I'm asking for actual acts of misconduct.
Because there's no body to make the legal decision whether something is actual misconduct, I can't point to a decision that's been made. I can only give you the allegations of the potential misconduct, which includes failure to recuse and improper travel.
Okay, all right. Let me ask each of you this, because I consider all of you students of the U.S. Supreme Court. What do you think will be the impact on the United States Supreme Court and people's respect for it as a result of this leak about the draft opinion in the Mississippi abortion case? We'll start on this end, and then I'll let Professor Payne rest a minute.
It was already on. You know, it's an empirical question. I really couldn't say. I think that the leak, the substance of the leak, which shows that the court is going against the majority of the country, is much more damaging to the legitimacy than the leak itself.
Thank you, Professor.
Well, the leak last night's obviously outrageous and should be taken very seriously, but I have a lot of confidence in the court and the American public, and I think that the Supreme Court is going to rise above the circumstance and, as it's done for decades, apply the rule of law and issue a decision that it believes reflects the constitutional principles in the Dobbs case and all others, and trust that the Chief Justice and the court will be able to resolve and issue an honest opinion quickly.
Okay. Professor Frost?
I think the leak was unethical, but I do not think it will damage the court. And I think far more damaging to the court was the failure to fill a seat for nearly a year when a nominee by then President Obama was pending and not acted upon.
Okay. Professor, You're a professor too.
Thank you. I think the leak was seismic, devastating, and heartbreaking. It should go without saying that the Supreme Court can fulfill its Article III responsibility if drafts of opinions are leaked and circulated for what appear to be political purposes. That said, I do think the Supreme Court is fully capable of keeping its eye on the ball and deciding this case ultimately through a final official published opinion in the way that the law and the Constitution command.
Professor Payne.
I think the leak was highly inappropriate, and it also raises the question of what are the specific rules that apply to the officials and the employees in the Supreme Court, because it's not clear about their duty of confidentiality as opposed to the duty of confidentiality for all of the other clerks across the lower courts.
Okay, thanks to you all.
So we have as people arrive and step out, we have a new list, a new order of proceeding, which is Senator Blumenthal, Senator Graham, Senator Durbin, Senator Lee, Senator Hirono, Senator Cruz, and Senator Hawley, subject to who is here as we go forward. So I'll turn to Senator Blumenthal, but before I do, I just wanted to note that in the record is the letter from Gabe Roth that I put in at the opening of the hearing, and anybody who is interested in a list of areas of potential judicial misconduct. Obviously, it's impossible to prove because there is no body to go to with those concerns. But to answer your question, the Roth letter, I think, provides a pretty good summary. And Senator Blumenthal.
Thank you, Chairman Whitehouse and Ranking Member Kennedy for having this hearing. It's an important hearing on an important day, and there are few topics more important than the United States Supreme Court as an institution. And lest we immerse ourselves too much in the abstractions and seemingly sometimes arcane discussion of rules, we ought to keep in mind that countless American women right now, today, are feeling afraid, alone, anguished, and really angry. Why does that matter? Because the United States Supreme Court, as an institution, is nothing without credibility and trust from the American people. It has no armies, it has no police force, it has no power of the purse. And anyone who has clerked, as I have in the United States Supreme Court, is aware that the justices themselves have to keep in mind that they are stewards of an institution. So when they come before the United States Congress in their confirmation, they say, we have respect for precedent. We believe in stare decisis. And then they, in effect, say, as the draft opinion does, well, stare decisis doesn't really matter that much when it's the Constitution. It undermines fundamentally the trust and respect that the American people have for the United States Supreme Court. And nothing is more precious and more essential to its power. And once it's lost, I worry deeply that it will never be repaired. So the court as an institution, I think, is gravely in peril right now. The topic that brought us here and the reason why we scheduled this hearing obviously has to do with other issues that involve conflicts of interest and the need for a code of conduct that the Supreme Court would set itself under legislation that I've joined in co-sponsoring. I'm proud to be a supporter of the legislation led by Senator Whitehouse. But what we're dealing with here is an institution that is so rare in our American democracy. It's unelected, appointed for life, unreviewable, basically unaccountable. In a democracy where all of us are elected, the president's elected, members of local planning and zoning boards are elected, the alternates to those members are elected, in Connecticut at least. So it seems to me the Supreme Court itself ought to be in favor of this kind of basic fundamental accountability. And of course, members of the court have said, Justice Kennedy, Justice Kagan, and others have testified they are considering it. Year after year, we're considering it, but they haven't done it. Without a mechanism for accountability and without disclosure, the minimum that ought to be expected, Supreme Court justices are free to rule in cases where the public could reasonably believe they have a conflict of interest, as in owning stock in the companies that are involved in the cases before them. And this has affected justices across the board. Justices Breyer and Alito failed to recuse in Feng versus Commenda and Rockwell Collins, even though they both own shares in Rockwell's parent company, United Technologies. Justice Alito failed to recuse in Merck, Sharp, and Dome Corporation versus Albrecht, despite owning shares in Merck. Chief Justice Roberts failed to recuse in BB Inc. versus Arizona Board of Regents, despite owning shares in Texas Instrument stock, a party to the ABB side. So I could go on at some length, but let me just ask Professor Frost, do you think that this legislation can help, even now, preserve the Supreme Court's credibility?
Yes, I do. I think if you're talking about the proposed bill and the ability of the Supreme Court to come up with its own code of conduct, I think that is the best solution. What I would hope would happen as a result of hearings like this and proposed legislation like this is that the Supreme Court would wake up and take action. This bill suggests that the Supreme Court itself develop a code of conduct for itself, and as you've noted, Justice Kagan said the court was seriously considering that in 2019. So we're really just giving a nudge to the court. This will improve the operation of the court, this will improve its integrity, and take this ball and run with it. You craft a code of conduct for yourselves, and this branch of government won't interfere. We're just pushing you to go ahead and do so as you suggested you want to do yourself.
Mr. Payne, do you agree?
I do agree. I think that with the code of conduct, the justices can have clear rules and clear interpretation of those rules to improve the public's perception that they take ethics seriously and are impartial.
Thank you. My time has expired, but I appreciate, Mr. Chairman, you having this hearing and leading this legislation. Thank you.
So, thank you for joining us, Senator Blumenthal. We've been working together on this, so your partnership is much valued. And over to you, Senator Cruz.
Thank you, Mr. Chairman. Yesterday was a truly ominous day in the history of the Supreme Court. Last night, the leak of what purports to be a draft opinion that was circulated by Justice Alito to the court marks an unprecedented breach of the trust that every justice, every law clerk, every employee of the court owes that institution. Very little in life leaves me speechless. When I saw that news, I was truly flabbergasted. It is impossible to overstate the gravity of the violation. The ethical violation, very potentially the legal violation, the wound to the independence of the court and to the integrity of the court may well be a wound from which the court never fully recovers. The decision of an immoral and unethical individual to leak the court's confidential working documents is the predictable consequence of a multi-year effort by Senate Democrats to politicize and undermine the court. Senate Democrats have systematically tried to turn the court into a mini legislature where 5 unelected lawyers wearing judges decrees the rules for the country regardless of what the voters believe. The The chairman of this subcommittee wants to force the names of any individuals behind amicus briefs to be made public, which would enable liberal activist groups to harass and dox them for engaging in the process. The Supreme Court shut down those same tactics in the 1960s when Democrats yet again wanted to harass members of the NAACP who were fighting for equality before the courts. The Supreme Court prevented that. In 2020, Senator Schumer went so far as to threaten two justices by name standing in front of the Supreme Court for the potential decisions they might make. He said, quote, "I want to tell you, Gorsuch, I want to tell you, Kavanaugh, you have released the whirlwind and you will pay the price. You won't know what hit you if you go forward with these awful decisions." Naked politicizing of the court. In 2021, left-wing groups announced plans to protest at Justice Kavanaugh's home in a clear effort to intimidate him and to threaten the safety of his family. Groups like Demand Justice, the left-wing group, launched shameful bullying tactics directed at trying to force Justice Breyer to retire and pave the way for a younger, more activist justice. Demand Justice took out ads and even hired a mobile billboard truck to pressure Justice Breyer to retire. And we are seeing an ongoing false character assassination directed at Justice Clarence Thomas by Democrats in both houses of Congress. In my view, Justice Thomas is one of the finest justices ever to serve on the court, which is precisely why this deliberate effort to politicize the court is so dangerous. And I would point out that these left-wing organizations funded by the dark money organizations the chairman of the subcommittee loves to talk about, dark money organizations like Arabella Advisors, left-wing groups that fund millions into putting leftists on court, including funding Demand Justice. Well, the executive director of Demand Justice, a former staffer to Chuck Schumer, tweeted last night, quote, "SCOTUS leaks are good. Elite lawyers on both the left and right treating the court as precious all these years have just been giving cover to an institution that is wholly unaccountable. Rip the veil off." Another left-wing activist, an individual named Ian Millhiser, on Twitter said, quote, "Seriously, shout out to whoever the hero was within the Supreme Court who said, F it," and by the way, he didn't abbreviate it, "let's burn this place down." Mr. Dupree, you have had a career litigating in front of the courts of appeals and the Supreme Court. What are the consequences for the court, for the independence of the judiciary, for the integrity of the judiciary, for the ability of the court to decide cases if an initial draft of an opinion can be leaked to the public and if political lobbying and pressure is brought to bear on how the court decides the cases?
Senator, the consequences would be devastating. And to your point, I do fear for the future integrity of the court in the wake of this stunning action that happened last night. As you know, the framers created the Supreme Court as a deliberative body, and a key element of those deliberations and the exercise of their judicial authority is the concept that deliberations are conducted behind closed doors, in secret, so there can be an exchange of views, debate over the law, draft opinions circulated. And when you see that process dynamited, to the quote that you read, burning this place down, it is a dagger at the heart of the Supreme Court's Article III power to decide cases or controversies. If justices circulate draft opinions with the knowledge that if there is one disaffected person in that building who has access to that opinion, that draft opinion will be on the front page of the New York Times in the morning, devastating to the Supreme Court's ability to do its job under our Constitution.
Thank you.
I will ask consent to put into the record of these proceedings the letter put out today, I should say the statement put out today by Chief Justice Roberts regarding the publication of a copy of a draft opinion. And to Senator Kennedy's point about investigation, it concludes with the following sentence: I have directed the marshal of the court to launch an investigation into the source of the leak. And then I would also read into the record the following quotation, which actually relates to the case at issue, the abortion cases before the court now. The following statement that Laura Ingraham made on Fox News before a vast audience. She said, "We have 6 Republican appointees on this court. After all the money that has been raised, the Federalist Society, all these big fat cat dinners, I'm sorry, I'll replace her word, irritated about this. If this court with 6 justices cannot do the right thing here, then I think it's time to do what Robert Bork said we should do, which is to circumscribe the jurisdiction of this court. And if they want to blow it up, then that's the way to change things finally." So just adding that to the litany that Senator Cruz described.
Mr. Chairman, while we're adding things to the record, those tweets that Senator Cruz just mentioned, could we
Without objection.
could we add those to the record as well?
Great.
About blowing up the court? Okay.
Senator Rono.
Thank you, Mr. Chairman.
Blumenthal.
Well, apparently, Chief Justice Roberts is going to get to the bottom of the leak, which is being characterized as the stunning thing that's happening. Well, you know what? I should think that we should be so much more stunned by the fact that the radical right-wing justices on the Supreme Court are prepared to eliminate a constitutional right that the women in this country have relied on for almost 50 years. That is the stunning thing, and what the aftermath of that kind of a ruling is going to be for women and their families all across our country. That is the stunning thing that the Supreme Court, radical Supreme Court justices are doing. And then I ask, what's next, Mr. Chairman? Because we know that Justices Thomas and Alito have already signaled their desire to revisit Obergefell, which is the Marriage Equality Act. As far as I'm concerned, anybody in this country who cares about our civil rights and indeed our constitutional rights should be very, very concerned about what this court is prepared to do, at least the radical right justices of this court. Regarding this hearing, Mr. Chairman, I have a question for Professor Frost. The Supreme Court has existed for more than 20 years without an official code of conduct. However, in recent years, there seems to be an increasing need for such a code. Is there any reason why the Supreme Court should be excluded from a code of conduct?
No, I think not. And I think they needlessly damage their own reputation by being the only 9 justices out of the entire federal judiciary who are not subject to a code of conduct. At times, they say they follow the code of conduct for lower federal court justices, but I think we all know that it's one thing to say, well, I might follow a law I don't think applies to me or I know doesn't apply to me, versus there is now a code that applies to them. So, for example, if the speed limit on the road said, maybe we'd like it if you drove 60 miles an hour, but you don't have to, the chances are you'd speed in a way that you wouldn't if you knew the law applied to you. And so for that reason, the Supreme Court should do what it has occasionally said it wants to do, which is create its own code of conduct and then follow it.
Is there anything that prevents Congress from requiring the Supreme Court to establish or adopt a code of conduct?
Not at all. This Congress has the authority under the Constitution to require the Supreme Court to have a code of conduct and follow it. And that is consistent with decades, indeed centuries of legislation by Congress regulating the judicial ethics of all Article III judges. To be clear, of course, Congress has no authority to interfere with the decisional independence of the court, and that is not what we're talking about. We're talking about ethics codes, and that is squarely within Congress's authority.
We've been hearing a lot about, on the full committee as well as on this committee, the influence of dark money on the selection of judges, particularly the amounts of money spent by the Federalist Society and their ilk. So I would recommend to all of our Republican colleagues that they vote for the Disclose Act, which will require disclosure of dark money donors. That is a clear indication of whether or not that the Republicans and their continuous concern, so-called concern about dark money influence, they can put their votes where their mouths are. For Mr. Payne, here in the Senate, we are bound by strict ethics rules, and it seems like the judicial branch is not subject, not it seems, it is. The judicial branch is not subject to such rigorous rules when it comes to the disclosure of gifts, travel, and income. Can you explain the major differences between the gifts and hospitality that can be accepted and must be disclosed by a member of Congress in contrast with what can be accepted and must be disclosed by Supreme Court justices?
Yes. So in Congress, the members can accept travel from privately sponsored, from private entities, but that travel has to be disclosed and it requires pre-approval. But with the court, they can accept this travel, there's no pre-approval, and the disclosure only happens at the end of the year, and that leaves the public in the dark with determining whether there are any potential conflicts of interest. And also, the personal hospitality exception is interpreted with the Supreme Court very broadly, as opposed to with the members of Congress.
So basically, without a very clear code of conduct, without a very clear requirements for recusal, without the requirement for disclosing of gifts and travel, et cetera, basically the Supreme Court is unto itself and it can do whatever it wants in this area. Isn't that right?
There is no check on their ethical decisions and no decisions to show that they are incorrect.
And as the Supreme Court continues to be faced with decisions that will impact all of our lives, i.e., overturning Roe v. Wade, I think it is stunning that they do not have a code of conduct and ethics provisions that applies to them. Thank you, Mr. Chairman.
Thank you very much, Senator Hirono. And for the record, Senator Hirono referenced the amount of money that has been spent in this effort to insert judges of a specific point of view onto the court, and Center for Media and Democracy has now pegged that number at $580 million. This was no small operation to capture the court. Senator Graham.
Thank you, Mr. Chairman. I think the way we captured the court is that we won elections and we picked people consistent with the philosophy we ran on. And our friends on the left are spending money, try to shape the court. And at the end of the day, we all have to make a decision as a member of the Senate what's best for the country and the court. Our views will be different, but let's see if we can find some common ground here. How many of you support the idea that a justice of the Supreme Court should be more like Congress in terms of reporting trips, have limitations on what you can take from the private sector? Raise your hand. If you oppose that, raise your hand. Why would you oppose that? Jennifer?
Well, I just don't, I think your question was posed like members of Congress, and so I think just the court is not a political institution, and so doesn't.
It's a public institution.
It is a public institution. I think that the current rules that are in place have been operating adequately for the justices' report their travel rules already and gifts that they receive, and are doing their best, I think, across the board to try to apply the rule of law
I'm not
fairly.
casting dispersions on the court, but nobody can send me to Europe for a month, pay my bills, and have me teach a course.
Well, I think the rules that are in place currently have been operating to require the justices to report many of those
Well,
things.
it's one thing to
and
report it. It's
adequate.
another thing. Is that Mr. Dupree, is that a good thing? To have a private group be able to send a justice to the Supreme Court for 2 months in Europe?
Well,
Either way, and
I guess a few thoughts, Senator. I guess the first thing is I think it's a good thing when justices are invited to give speeches, to teach law school courses. I think that...
yeah, we're invited to give speeches, but nobody can put me up for 2 months in Italy.
So I'm answering the portion of your question, is it a good thing that Supreme Court justices and other judges go out, share their views before audiences, some public, some private, some academic? As a general matter, yes, I think it is a good thing.
But as to my specific example of a private organization basically paying for weeks abroad.
Well, if I guess I don't have a problem with the current system. My view, to Professor Mascott's point, is I think our...
Well, I do. Okay, that's fair enough. And that's why you're here. I have a serious problem with the current system.
I think that our justices are, without exception, persons of high integrity.
I'm not saying they're not. I feel that way about my colleagues, but because it's a public confidence thing, I think there is bipartisan support, Mr. Chairman, to rein in sort of how the court operates to make it more transparent to the public. But this bill goes well beyond that. So I share your concerns about where this bill is headed. I make this point that there is bipartisan support for controlling sort of the interaction of the court and the private sector to make it more transparent, to make sure that there's no appearance of impropriety, and count me in for that. And very briefly here, what happened to the court, how many of you believe that leaking the draft opinion was bad for the court? Okay, we all agree. And the reason it's bad for the court is going to be hard in the future to trust each other, to form consensus, to share ideas, to build consensus and to get votes for a particular position. So I think this is a giant step back for the rule of law. How many of you believe that Justice Roberts should be in charge in the investigation? Yeah, me too, right? There's some effort by folks to basically reach out and take over the investigation. Let's let it happen in-house, and we'll see what he finds, and as a nation, we'll figure out what to do. So this is a bad day for the rule of law, and I don't know who did it. Your motives, I don't care what your motives were, you did a lot of damage to our country, and I don't know if we can repair this, but we'll try. So my hope is that this effort to regulate the court and make it more transparent and control interactions with the private sector will prevail. I hope the effort to expand the court because you don't like its makeup will fail. I hope the effort to change life tenure will fail. I hope the effort to abolish the Electoral College will fail. And all these attacks on the institutions to get outcomes will fail. As to Roe v. Wade, always thought it was a constitutional overreach. If the draft opinion holds, then each state will decide how to regulate abortion. Thank you for having this hearing, Mr. Chairman. In this bill, there is a pony.
You have long been a supporter of that pony, Senator Graham, and I appreciate it very much, and I look forward to continuing to work with you to accomplish those goals. I couldn't agree with you more that this interaction between justices and private sector special interests is an area that merits much, much effort. And to the point of this being a bad day for the court, I'm no fan of the leak, but I think the bad day for the court was primarily its apparent destruction unilaterally of a 50-year-old precedent on which Americans have come to rely largely because they were picked to do just that. So that's, to me, the real tragedy here. Senator Lee.
Thank you, Mr. Chairman. It's important to remember the unique role that our court system and the Supreme Court of the United States in particular plays within our constitutional framework. The Supreme Court is there not to decide matters of public policy according to public will. It is there to exercise judgment, to interpret provisions of federal law, whether part of a statute or the Constitution, when multiple parties properly before the jurisdiction of the courts disagree as to the meaning of the provision in question. It's why we give them lifetime tenure. It's why the Supreme Court and the other federal judges within our system operate with life tenure, subject only to impeachment and removal. It's because we don't want their decisions to be influenced by political agendas. That's the whole reason they're there. There have been times in our history when, tragically, we've veered from this vision. And when the courts have been used, I would say abused, in order to pursue a particular political outcome. It doesn't always take the same political direction. It doesn't always favor one side or the other. I can point to an instance, for example, in 1905, when the Supreme Court of the United States engaged in what I would regard as political maneuvering, invalidating a law duly enacted by the state legislature of New York to undo legislation prescribing minimum wage measures and maximum hour provisions on workers at bakeries. The Supreme Court concluded, in essence, this is important. It's important that individuals have the ability to contract with their employer. It's so important, in fact, that it must be in the Constitution. We deem it to be so. The name of the case was Lochner versus New York. It remained intact for 32 years. It was, in my view, some disagree with me, but it was, in my view, an act of judicial aggression into the political realm. The fact that it was 32 years old by the time the Supreme Court issued a ruling 32 years later in a case called West Coast Hotel versus Parrish didn't make it impervious to review and reexamination. To the contrary, it was high time that the court revisit that. So I don't understand why on this committee or in this body we should ever be talking about praise for a court that would engage in political manipulation. Now, some who are frustrated by their own attempts to use the court as a legislative superbody, something to put in place policies they favor but have been unable to achieve through the political process, through winning elections, having secured certain victories in court, then become incensed when the court no longer goes along with them. There were those who were furious in 1937 when the Supreme Court recognized the mistake it had made in 1905. In response to that, some might have tried to delegitimize the court. The court was certainly undergoing a lot of efforts to delegitimize it at the time. It was the same year that Franklin D. Roosevelt threatened to pack the Supreme Court. And although his threat ultimately failed as a legislative matter, it left an unfortunate, indelible mark. Those who are trying to undermine the court are doing grave harm one way or another. This unprecedented treatment of Republican-nominated justices on the Supreme Court, things that include but are not limited to the high-tech lynching of Clarence Thomas when he was before the Judiciary Committee more than 3 decades ago. There are other more recent examples, including Senator Schumer's very public attempt to threaten and intimidate the court in front of the Supreme Court building during oral arguments in the Louisiana abortion case known as June Medical. These and other moves to delegitimize the court are concerning. It also concerns me that this hearing may be more of the same, an effort to delegitimize the court, designed primarily to wage war against conservative justices and against the man that then Chairman Joe Biden failed to destroy in his attempted high-tech lynching of Clarence Thomas 30 years ago. So if today's Democrats can't control Justice Thomas, if their consistent and unrelenting efforts to caricature him have done nothing to intimidate him, then they want to do everything they can to delegitimize him. It worries me greatly that this leak occurred yesterday. This leak, we don't know exactly who did it, but we know that it might easily have been done. One could easily surmise that it could have been done by someone who was upset at the contents of the opinion of the court with Justice Alito's name on it. To the extent this was an effort to threaten, intimidate, and harass those justices inclined to support that opinion, it's disgraceful. It's disgraceful either way. And to suggest that the true injury here is somehow that inflicted by that opinion gets it completely 180 degrees backward. In 1973, the Supreme Court of the United States deviated into an area outside of its jurisdiction, outside of the realm of the Constitution, adopting a policy aim motivated by a political agenda that is nowhere in the Constitution. Those justices, starting with my former boss, Justice Alito, who authored that opinion, and those inclined to join it, should be praised, not condemned and ridiculed. Now, I understand not everyone on this committee is going to agree with my assessment on that, but we should agree with the need to protect and defend the legitimacy of the court, even when we disagree with it, not attack it. And that's what's going on here. Thank you.
Thank you, Senator Lee. We have Senator Hawley here now. So, Senator Hawley, you have 5 minutes.
Thank you, Mr. Chairman. What a timely hearing. Professor Mascott, am I correct in thinking that you were a Supreme Court clerk?
Yes, for Justice Thomas.
Have you ever heard of a decision, a full draft opinion being leaked months before a case was to be decided? Did that happen while you were on the court?
It did not happen while I was a law clerk there, and it's really unprecedented in its breadth and shocking.
You know, it didn't happen when I was there either, when I was working as a law clerk. I've never heard of it happening. I'm not aware of this ever occurring in the history of the Supreme Court, a deliberate leak, along with vote tallies as well, in what is plainly an attempt to influence the deliberations of the court and to change the opinion of the court. Tell us about the effect of this from an Article III perspective. What's the effect on the independence and integrity of the judicial branch?
Well, Senator Hawley, I think it seems clear from the that the leakers' hope is that this will intimidate and it will undermine the legitimacy of the court and make it seem like it's not operating smoothly, where the court, I think, has been operating actually with quite a lot of collegiality. The justices are trying to apply the rule of law, and I trust that they will be able to overcome this and issue the correct constitutional decision in this case.
Mr. Dupree, same question for you. I mean, Article III independence and integrity is very important. It is increasingly under assault. We saw this before, back during the first Obamacare case. We saw a concerted effort in the press beginning at about this time of the year to pressure the court into a particular outcome. But this is a radical escalation. I mean, a radical breach of the court's confidentiality, a radical breach of the court's procedures, something that really strikes at the independence of the court itself. Tell us about your view on this. I mean, what's the damage that is being done to the court here?
I think it's a devastating action, what happened last night. And as you know, the Supreme Court, in order to fulfill its Article III authority, needs to deliberate in private. There needs to be an opportunity, a forum for a candid exchange of views, for the exchange of draft opinions as the justices work through these thorny constitutional questions. And when you have something like what happened here, which by all appearances appears to be a deliberate and calculated political act done for the purpose of influencing the outcome of the course, changing the course of the court's deliberations, it violates the sanctity of the fundamental core Article III role that the Supreme Court plays in our democracy. It's outrageous.
It truly is outrageous. Now, what about all of these liberal dark money groups that are piling on today and gleefully celebrating this, calling this leaker a champion of democracy, saying that this is celebrating it? I mean, saying that this is just wonderful. I mean, isn't this a calculated attempt to try and undermine the integrity of the court, the independence of the court, to try and destroy, basically, its independence?
I think it's a situation where you have people who are unhappy with the outcome. And in reaction to that thinking, they don't like what the Supreme Court appears poised to do. They basically want to tear the institution down. They want to dynamite the Supreme Court. They want to blow up the House. It's shocking and outrageous to me that people would treat an institution that, from many perspectives around the world, is one of the crown jewels of our constitutional government, is the United States Supreme Court, and that someone would do something like this, a direct attack on the integrity of the court in order to achieve their preferred political outcome, to me is abominable.
And presumably from inside the court. I mean, something I notice about this leak is this person knew the vote count. This person knew, they didn't just grab an opinion that was circulating around. This person knew what the vote was. They knew what it was on the day it was cast. They knew the status of the vote right now. I mean, if this isn't an attempt to change votes and to try to alter that outcome, I don't know what the good of it is. If the person who leaked this is a member of the bar, what are the consequences there? Mr. Dupree, you first.
Well, at a minimum, I could see bar associations stripping that individual of their license to practice law. Beyond that, I think there are just professional canons of responsibility that would govern law clerks or people acting in a legal capacity. And of course, there's also the possibility of criminal jeopardy. I think we need to know a lot more about what happened here, but at a minimum, there would be very, very severe sanctions on whoever was responsible for this action.
Professor Mascott, do you have anything to add to that?
I agree with what Mr. Dupree said. I mean, as you know, as a former law clerk, the code of confidentiality and integrity there was of utmost importance. It's shocking that it was violated, and obviously the individual who leaked it would not be able to be a trusted member of the bar.
Yeah, I would think at a minimum we'd be looking at disbarment here. This is something I've never seen before. I'm not aware of it happening
on Fox News regarding this particular, which is we'd be very solemnly instructing that country that that was a terrible way to appoint justices. And yet that's exactly what we have been up to. Another operation goes into effect to campaign for them, spending tens of millions of dollars, receiving checks as big as $15 million. An effort to delegitimize the court. I see this as an effort to re-legitimize the court by bringing it to very reasonable standards, the standards to which the executive and legislative branches already adhere, the standard to which our district and circuit courts already adhere, and to principles that are so long-lasting in our society that they began in Latin. The thing that is peculiar right now about the court is the variation from the norm of the selection, confirmation, and solicitation of justices by enormous, enormous, enormous floods of anonymous money. And I will stand with Judge Selya of the First Circuit, a Rhode Islander, who in a recent decision that now stands, because the Supreme Court declined to review it, described how it's one of the very important attributes of citizenship that citizens be allowed to understand who is doing the talking. Citizens have an important role in our democracy. And if you disable them from the most basic element of knowledge of who is doing the talking so that everything comes to them from behind masks, from behind front groups, from behind organizations that they know not to be real in their real lives, it does enormous damage to our democracy. And in court, it gets even worse. The judges in a court, the other parties in a court, and the public watching a court proceeding have a right to know who is showing up and what their motivations are and whether they've all been orchestrated by an outside influence. You'd think that a principle like that would be non-controversial. That seems like pretty basic stuff. So I hope as we work our way forward, that type of common sense and long-standing principle can prevail in this discussion. And I will ask that a letter that Senator Lee would like to have put into the record from an article by Jeffrey Rosen through the American Enterprise Institute be added to the record of these proceedings, and also a letter that I will ask to be put in from the Leadership Conference on Civil Human Rights be put into the record. And I would also, since time has expired, ask each of the witnesses to reflect on the situation in the recent case of Americans for Prosperity Foundation versus Bonta. And the facts that I would like you to reflect on are that Americans for Prosperity is the political battleship of the Koch brothers' dark money political operation, and it spent millions of dollars pressing for the selection and confirmation of the last three justices, which would seem to implicate Caperton versus Massey. And Americans for Prosperity Foundation is the 501c3 twin to the Americans for Prosperity 501c4. This is standard operating political practice now. You twin a 501c3 and a 501c4, and you get the tax deduction and the secrecy for the 501c3, and the 501c4 can act politically, and they very often have the same staff, same location. The way I describe it is that the corporate veil between these 501c3s and 501c4s could be pierced with a banana. And yet, in deciding the Americans for Prosperity Foundation case, none of the justices even discussed the question of whether they should treat that petitioner as related to or even identical in fact to Americans for Prosperity, and consider whether or not Americans for Prosperity's millions of dollars in spending to get them on the court should justify recusal. Now, I think it's an obvious they should have recused. Boom, slam dunk. I think that's an easy call. They may have a different view, and they're entitled to have a different view, but they should relate that different view so that people know what the recusal standards are. To Mr. Dupre's concern that there will be a surge of activity if we open these gates, yeah, and that surge of activity will define the rules so that everybody understands and so that the rules themselves are open, and it puts behind us this era of everybody being judged in their own cause with no accountability, with no consistency, and with no apparent principle. So anybody who cares to respond to that AFPF, AFP situation, I'd be delighted to hear your considered and thoughtful views with time to reflect and time to write to the committee, and the record will close to allow you to do that if you wish in 1 week. So if you're interested in doing that, you've got a week. Let me thank all the senators who participated. The witnesses were all very helpful. I appreciate your views. And with that, the hearing is concluded.